We've covered the harms and the principles. Now the rules. This module is your map of how AI is regulated around the world, the philosophies, the instruments, and how the pieces fit together before we go deep on the specifics. Here's the shift that defines this whole arc of the course. For years, AI ethics was voluntary principles, pledges, we should be responsible. But principles are optional, and law is not. And between 2024 and 2026, AI crossed that line. It moved from self-regulation into binding obligation, with real penalties attached. So your job as a governance professional changes. It's no longer enough to know what good looks like. You have to know which laws actually bite, on whom, and by when. That's what this module starts, and what modules 5 and 6 finish. Different parts of the world are regulating AI in genuinely different ways, 4 broad philosophies. The risk-based approach, pioneered by the European Union, your obligations scale with how risky the use case is. The principles-based approach, exemplified by the UK government, sets high-level principles, and existing sector regulators interpret them for their industries. The rights-based approach, embodied in the Council of Europe's treaty, everything anchors back to human rights and the rule of law. And the fragmented or sectoral approach, which describes the United States, a patchwork of state laws, sector-specific rules, and executive action. Same destination, trustworthy AI, but for very different roads. And a global company has to drive all 4 at once. Of those 4, the risk-based approach has become the dominant model worldwide, so it's worth understanding deeply. Picture a pyramid. At the top, a small set of uses considered so harmful they're simply prohibited, unacceptable risk. Below that, high-risk uses, which are allowed but carry strict duties. Below that, limited risk uses, which mainly require transparency. And at the base, minimal risk uses, which are essentially free to deploy. The key insight is what's being regulated, not the technology itself, but the use case and the rules scale to the stakes. Learn this logic once, through the EU AI Act, and you'll recognize it in law after law around the world. Now a distinction that trips up even experienced professionals: there are 3 different kinds of instrument, and they are not the same. First, a law or regulation like the EU AI Act. It's mandatory. Break it, and you face penalties. Second, a framework like the NIST AI Risk Management Framework. It's voluntary guidance, you choose to adopt it because it's useful. And third, a standard like ISO 42001. It's also voluntary, but it's certifiable, which means an independent accredited body can audit you and issue a certificate. So, a law binds you, a framework guides you, and a standard lets you prove you. Confusing these categories leads to real mistakes, like treating helpful guidance as if it were mandatory, or worse, the reverse. Let's put our 3 anchors side by side, because this table is the spine of the whole course. The EU AI Act, a binding law from the European Union that applies to AI placed on or used in the EU market. Its focus is product safety and fundamental rights, organized by risk tier, and it has serious teeth, fines up to €35 million or 7% of global turnover. The NIST AI RMF, a voluntary framework, from the US, usable by any organization, focused on managing AI risk across the lifecycle, with no legal teeth. Its weight is reputational and contractual. And ISO 42001, a certifiable international standard, for any organization, focused on building an AI management system, enforced through certification by an accredited body. Read across that row and the headline is this: they're complementary, not competing. One good implementation can serve all 3. A lot of people outside Europe assume the EU AI Act isn't their problem. That's a costly assumption. The Act applies to AI that's placed on the EU market, or whose output is used within the EU regardless of where the provider is physically located. So a US company whose hiring tool is used on candidates in Europe is in scope. This is the Brussels effect, and we saw it with GDPR. EU rules become a de facto global benchmark, because for most companies it's simply impractical to build one version of a product for Europe and a less governed version for everyone else. So they comply everywhere. That's why the EU AI Act is the reference point the entire world measures against. A common misconception is that you have to choose between these, pick the EU Act, or NIST, or ISO. You don't, and mature programs don't. They fit together in a stack. ISO 42001 provides the outer shell, the management system that organizes everything. Inside it runs the NIST risk process, the actual work of mapping, measuring, and managing AI risk. And the evidence all of that produces is exactly what demonstrates compliance with the EU AI Act's requirements. The standard structures it, the framework runs it, the law sets the floor. Layered, they reinforce each other instead of duplicating effort, which is the whole efficiency case for doing this well. So how do you figure out which of the world's overlapping rules actually apply to you? Use Scope, with 5 questions. 1. Where is the AI placed, or where is its output used? That sets the jurisdiction. 2. What does it do? The use case determines the risk tier. 3. What role do we play, provider or deployer? 4. What sector are we in? Finance, health, and employment all add their own rules. And 5. Whose data is involved? Privacy laws overlap heavily with AI rules. Scoping is always step 1 of a governance program, because you cannot comply with or even budget for obligations you haven't mapped. This is the unglamorous work that everything else depends on. Let's run Helios through that scoping. Its hiring tool operates in both the EU and the US. So, under the EU AI Act, it's high risk, because employment is an Annex 3 category. In the US, it triggers New York City's bias audit law and various state automated decision laws. On roll, Helios bought the tool from a vendor, so the vendor is the provider and Helios is the deployer, and each has different duties. On sector, employment law adds its own anti-discrimination requirements. And on data, candidate data pulls in GDPR in Europe and CCPA in California. One tool, a whole stack of overlapping regimes. That looks daunting, but it's completely typical, and now Helios has its obligation map, which is the first real deliverable of its governance program. To recap, AI is moving from voluntary ethics to binding law. There are 4 regulatory philosophies: risk-based, principles-based, rights-based, and fragmented. There are 3 kinds of instrument: law, framework, and standard, and you must not confuse them. The big 3, the EU AI Act, NIST, and ISO 42001, are complementary and best run together. The Brussels effect makes EU law a global benchmark. And you always scope first. Next, we go deep. Module 5, the AI regulations themselves, starting with the EU AI Act.